This original WSRE presentation is made possible by viewers like you. Thank you.
Senior federal judge Roger Vinson on this edition of Conversations. For over 30 years, Judge Roger Vinson has served the United States District Court for the Northern District of Florida. He was appointed to the post by President Ronald Reagan. Vinson held the position of Chief Judge from 1997 to 2004 and has been a senior judge since 2005. In addition to his district judgeship, he also serves on the Foreign Intelligence Surveillance Court. He's a graduate of the United States Naval Academy and Vanderbilt University School of Law. We welcome Federal Judge Roger Vinson to Conversations. Thank you for joining us.
Hey, Jeff. Thank you for having me.
Curious, how did you go from naval aviator to law?
Well, it's a long story, but basically when I was in the Navy, you get appointed to handle court-martials. And when I was doing that, and I served on 3 court-martials altogether, and I decided I sort of enjoyed it. And during those years, I'd gotten to know some lawyers and sort of decided that was probably a good line of work for me with what I thought I had some talent for. So that's how I ended up deciding to go to law school.
Okay. And so you were at Vanderbilt, graduated, and then?
I went to Vanderbilt. Vanderbilt was kind enough to offer me a very nice scholarship, which probably was an added incentive because I was considering becoming an airline pilot about that time. And a lot of the airlines were interested too. So Vanderbilt made a very good offer, and I was very glad to receive it and very glad and thankful to Vanderbilt that that's the route I took. I owe them a lot. Yeah.
Great school, by the way. So you're in private practice. So how did you make the transition? How did it come about from private practice to being a judge?
Well, after I graduated from Vanderbilt Law School in 1971, I came back to Pensacola and practiced here in Pensacola, civil practice, no criminal, but all civil, general civil, for 12 years. And occasionally there's a vacancy on the federal bench, and there was a vacancy, and I thought, well, this may be the only opportunity I have. You never know when another one's going to come along. So I decided to see if I could get the position, and I ended up getting it. So that's why I'm here.
Okay. And that was, what, 1985?
1983.
Or 83?
1983, okay. 30 years ago.
Okay. So President Reagan appointed you? And
he did. President Reagan was the only president to really call all of his nominees up. He called them up personally and had a little conversation with each of his nominees, which was really a personable thing that he did.
What was that conversation like?
Well, it was interesting. I was actually out of the office. I was in a conference over at one of the local banks with a rather important meeting, and they interrupted us and said, Mr. Vinson, the president's on the phone. So I said, well, I'll take it. So that's how I ended up with the conversation. And he ended up by saying, give my best regards to Ellen and all the children. You know. So yeah, I'm sure he had a card in front of him with all of that, but that's a nice touch.
Absolutely. Must have made you feel really special.
It was, yeah.
Absolutely. Pretty soon in your career, you ended up with a pretty high-profile case, the Christmas Day abortion bombings that took place in Pensacola, Florida. What was that like, such a high-profile?
Well, it was. Actually, I had a very busy trial calendar as soon as I was sworn in. I immediately was... The first 2 cases I handled each of them were over 2 weeks long, big, long drug conspiracy cases. The most serious case you could have in federal court in those days. It was the only one that actually carried a life sentence. It was big, but the Christmas Eve bombing case was unusual in that it was the first one to receive sort of national attention. That was when CNN had just gotten cranked off good. And they actually sent the first satellite truck that I think I remember seeing, they sent one down to Pensacola and set up the truck out in front of the courthouse and had basically constant coverage from outside. We don't allow cameras in federal courtrooms, but they had regular bulletins, on the hour, half hour, reports on how the trial was doing. We had to set up a special room in the courtroom and do a wire integrity test to make sure that nobody tapped in or somehow was able to listen into what was going on. But the press was set up. I think we had at that time over 80 members of the press in attendance at the trial, which at that time was really something big for Pensacola and even for Florida. We'd never had anything like that in our court before.
Your role as a judge when the press gets that involved, how does it change things for you, or does it?
Well, it really didn't change anything for me. We didn't do anything differently as far as the trial was concerned, but it was different as far as the court personnel. We had to make sure everybody had to have a pass to get in. We didn't have that many seats in the courtroom, and by the time you had the family members and the parties and the attorneys had quite a large assortment of people helping them. We had a lot of people that volunteered to take the defendants' cases. In fact, several faculty members from Notre Dame Law School and a couple of other law schools came in to help. It was quite crowded, so the marshals and the court security officers had their hands full.
Mm-hmm. How did you approach it? What was your approach?
Well, I enjoyed the trial. I was wanting to make sure that everybody got a fair trial. That was the most important part. And we had the jury sequestered. We took over an entire floor of the Crown, what's now the Crown Plaza, and we had marshals stationed by the elevator and made sure that the phones were all disconnected and they couldn't watch the news and all that sort of thing. So it was really a major operation to sequester the jury, to make sure that there was no contamination of the trial. The jurors actually decided the case only on what they saw in the courtroom as admissible evidence, and made sure that everyone got a fair trial. That was my concern.
You mentioned that in federal court, television cameras are not allowed in.
That's right.
I think early on, Sonia Sotomayor had mentioned that she might be open for the idea of cameras being in the United States Supreme Court. I see where recently she said, well, maybe that's not a good idea after all. What are your thoughts? Should television cameras be allowed?
Well, there's a big difference between the Court of Appeals and the Supreme Court and the trial courts. You don't have to worry about anything except the lawyers and the judges in the appellate courts. Everybody else has to sit there. Nobody else talks. In the trial courts, everyone, including the witnesses, the parties, particularly the attorneys, everybody, if it's a high-profile trial, is going to be conscious of the fact that they're going to be watched by hundreds of thousands or maybe millions of people, and they're affected by that. Everyone has a little bit of an actor in them, and they all sort of want to play to that. So it changes the whole complexion of a trial. It just, by nature, it's going to happen that way.
You think of the O.J. Simpson
Sure.
trial.
I mean, that was the epitome of how not to do it.
Right.
And most people who watched that trial concluded that the wise thing to do is not televise them. Right. But that's the way the federal courts are now. State courts obviously do televise.
For people who don't know, I think it brings up an interesting something to educate all of us on, because sometimes I think we forget as we get away from our civics lessons, and the difference, the different roles that federal court plays versus state court.
Well, that's a very important question, because it goes to the very heart of the federalism concept that our government set up under. And initially, the federal courts were set up, and the Constitution provides for the U.S. Supreme Court and lesser courts to be appointed. there really was no U.S. Court of Appeals until the late 1800s. The Supreme Court sort of rotated around and sat with the district court sometimes, but the federal court system is designed to handle all the federal matters, and there are certain things that are exclusively federal jurisdiction. Admiralty is exclusively federal jurisdiction. Some of the crimes like treason, piracy, counterfeiting, those are obviously exclusively federal. But there are an awful lot of things that overlap, and that's frankly quite one of my concerns, is that there's so many things in the federal criminal laws that have been taken from the states for no real justifiable reason. And I think that's a problem. I mean, we've made a crime. The Constitution originally set out there were only, those crimes that I just mentioned: treason, counterfeiting of federal currency, piracy on the high seas, just a very limited number of federal crimes. And now, I think by last account, somebody said there's probably 45,000, because all the regulations have criminalized such things as environmental. If you violate an environmental regulation, you can be subject to a criminal fine and even imprisonment. I had a relatively high-profile case involving one of our local citizens about filling in a wetland to build his house, which was a federal crime, and he got sent to prison for it. I didn't send him, but he was sent to prison, and I ended up granting a habeas corpus on it. But it's amazing how the federal government, without any specific authority, has taken over such a wide area of the criminal area. In civil cases, it's totally different. There are a lot of things that need to be in federal court. There are certain things like securities laws and the tax laws and a lot of federal laws that definitely require federal court jurisdiction. But we also have diversity jurisdiction, which means parties from one state and another state, two different states, or anything that the U.S. government is a party to, then we have jurisdiction over that. So the long and short of it is we have greatly expanded civil jurisdiction because they're just exploding things because of exploding regulatory climate and so many bureaucracies that have been established. But the jurisdiction for diversity is important. Mm-hmm. It's nice if you're a citizen of Idaho and you have a case in Alabama. Sometimes you don't want an Alabama court dealing with it. You'd rather have somebody a little more objective, supposedly.
Right. I understand. It's fascinating once you start to get into the minutia of it. So essentially, you're saying that probably a lot of stuff would fare much better just being at the state court level.
Well, for example, a great proportion of our criminal cases involve drug cases, drug matters. All of those could be handled in in state court. The only ones that really need to be in federal court are the ones that overlap, that are truly national or regional in scope. We had a lot of them initially because a lot of our cases, when I first came on the bench, involved importation. We started out importing by boat across the Gulf of Mexico, then we started importing by aircraft across the Gulf of Mexico, and we had a huge number of those cases, big cases. But we don't have those anymore. Most of the drugs that we have now are being transported maybe on Interstate 10 or just distributed locally. So it's questionable whether we really need to get the federal government involved in a lot of these things. And firearms cases are almost always federal. Immigration cases have to be federal almost. They're turned over to the federal government. But aside from those, there's an awful lot of overlap.
Interesting. Any way to fix it easily?
Well, the sad truth is that laws get on the books and they almost never get off the books. So once you enact a law, it just keeps adding and adding and adding. And so we've got a criminal code now that started out just a few pages, and now it's voluminous.
Well, speaking of laws, I have to ask you about the Affordable Care Patient Protection Act, also known as Obamacare.
Well, you got the word right. That's good.
26 states filed suit
That's right.
against the federal government or Health and Human Services.
Within hours after President Obama signed the act in March of 2010, the suit was filed here in our court. Yeah.
Why was it filed in this court or your court?
Well, I don't have any personal knowledge of why it was filed here. I was told and have read that it was filed because they thought this was a good jurisdiction because we have relatively conservative judges here. Now, I don't know if that's true or not.
So it gets filed, obviously very high profile.
Yeah.
You ultimately made a decision on it, and take it from there. Tell me about it.
Well, it was actually from my part, there were actually two important phases. The complaint itself had a number of claims, 15 or I don't know exactly, but in that vicinity, a lot of claims. And they all were arguably good claims, but for various reasons, because of legal precedent or other matters, I was able to deal with them when the government and the agencies, it was actually filed against the secretaries of a number of different agencies, and they filed motions to dismiss. So the first phase of it was to winnow out those claims that really didn't have an arguable basis for proceeding to the next step. Some of them may have had factual issues and all sorts of things like that. So we had a lengthy hearing on that. They briefed all of that, and when I got through that, I said, well, there's the Commerce Clause question, and then there's the coercion on the Medicare question. Now, those were broken down into some subparts, and the major issue on the Commerce Clause is whether the federal government had the authority to impose the penalty upon anyone who does not take out the health insurance in accordance with the requirements. You know, the health insurance has to meet their standards. You can't just have a minimum amount. You have to have a high coverage standard. So that penalty became the number one issue. That was whether it was authorized by the Commerce Clause. And the Commerce Clause has been the peg on which most of the federal jurisdiction has been hung since the mid-1930s. And that's why when we talk about the expansion of the federal criminal jurisdiction, it's all been pinned on the Commerce Clause, oddly enough. Most people don't realize the federal government doesn't have police power. The city has police power, the state has police power, but the federal government does not have police power. So when people say, well, the state of Massachusetts can order you to have medical insurance or impose a penalty, if the state of Massachusetts can do it, why can't the federal government? Well, it's very simple. The state of Massachusetts has police power. They can order you to do all sorts of things, but the federal government does not have police power. They do not have that power. So that's why they have to find some other peg in the Constitution to pin it on, and the only one that's really applicable is the Commerce Clause, and that's why, with two minor exceptions, ever since the 1930s, Congress has always said, well, we're exercising our commerce power because it's in and affecting commerce or something like that. So that was the main issue. There were some secondary issues to that, and one is the government said, well, it is a tax and it's barred by the Anti-Injunction Act, which says you can't bring a lawsuit with respect to a tax until you actually pay the tax, and then you can sue the federal government for a refund. That's how most income tax cases get to court. You pay the tax and then you sue for a refund in federal court. The Anti-Injunction Act requires it to be a tax. The government argued that, well, it's a tax, so therefore the Anti-Injunction Act applies. So the first thing I had to do is say whether it's a tax or not, and I went through that at some length, 20 or 25 pages, in fact. Went through all the history of the legislation, all the different versions that had gone back and forth, all the words that they used, and concluded quite definitely it's not a tax. Even They don't call it a tax, but even if they call it a tax, it's still not a tax because of all these different things. On the Commerce Clause, the argument was made by the government that if the Commerce Clause directly doesn't apply, the Necessary and Proper Clause applies, which means the federal government has the power to enact legislation that's necessary and proper to its otherwise authorized enumerated powers. Well, the law is pretty clear, and there's a lot of case law on that. The Supreme Court says basically, necessary and proper means it's necessary and proper to something that's enumerated, but it still has to be an enumerated power. It still has to be, in our case, the Commerce Clause. So we dealt with that and said, no, it's not within the necessary and proper. It's not within the Commerce Clause, because what you're dealing with here is you're imposing a penalty on someone who does not do something. And all the case law going all the way back to the very beginning, and Chief Justice Marshall, all the case law says the Commerce Clause applies to, the instrumentalities of commerce itself, and those things, those activities that substantially affect interstate commerce. That's how it's been expanded and broadened. But every one of the cases says activities that substantially affect interstate commerce or interstate commerce itself. In our case, we don't have any activity. We have the opposite. We have inactivity. That's what the penalty is under the Affordable Care Act. So with respect to that, I said the Commerce Clause doesn't apply. It's not a tax. The Anti-Injunction Act doesn't apply. The Necessary and Proper Clause doesn't apply. And then with respect to the Medicare issue, I had reviewed all of the Supreme Court case law, and the Supreme Court had hinted that the federal government in some instances could coerce the states, and that would be improper. If it rose to the level that it was coercion of the states, and the states were not acting freely and voluntarily, then that was coercion and should be prohibited. But I said the Supreme Court hasn't said that in so many words, and they need to, so I invite the Supreme Court to do that. And that's how it ended up before the Supreme Court. They dealt with every one of those issues that I just set out for you, plus one more. And the court said, well, even though it's not a tax for anti-injunction purposes, it's not a tax in the common meaning of the word, it's not a tax for any other reason. If it is possible for them to have done it as a tax, and it's possible for it to be construed as a tax, Chief Justice Roberts said, we'll call it a tax to make it constitutional, because I had said you can't sever out this portion of this law because it's so intertwined. And it was. There were so many parts of it. I likened it to a very carefully crafted watch that had a missing piece, and you can't just take the missing piece out and let the watch work. It won't work. You've got to go back and redesign the watch. So that's why I said you can't sever it. It doesn't have a severability clause. Any number of reasons why you can't do that, and cited a lot of case law, of course.
Were you quite surprised that Judge Roberts voted the way he did?
I was surprised, frankly. Yeah, I didn't see no other court. And there were a number of courts that considered this entire subject matter. Not a single judge, not even in a dissent, had said this is a tax. Mm-hmm. Everyone had uniformly said it may be a Commerce Clause. It may be within the Commerce Clause, but it's definitely not a tax until it got to the Supreme Court. And they said, well, it is.
Yeah. Interesting. We'll get about 4 minutes left here. I want to touch on, you are a member of the FISA Court.
Yes.
Tell me about it. What is it?
Foreign Intelligence Surveillance Act Court, we call it, the Foreign Intelligence Surveillance Court. The FISA Court is set up. The law was first written in the late 1970s, and the court was set up to implement the review because primarily for electronic surveillance, but we also deal with every kind of surveillance: physical surveillance, espionage, counter-espionage, terrorism, anything involving a foreign power, which all foreign governments are foreign powers, obviously, plus all the terrorist organizations. So we are called upon to review applications. The Justice Department has a separate division within the Justice Department that has well over 100 lawyers that do nothing but present applications to us. And the applications are from the FBI, the CIA, the National Security Agency. All of those agencies come through us, and they ask us for approval before any surveillance can take place. And we have to not only approve it, but we put time limits on it. We put reports on what they have to do. Minimization, a lot of the surveillance has to be what we call minimized, which means you only listen to things that are pertinent or relevant to the intelligence side. If it's not within the scope of what you're supposed to be getting, you're supposed to either shut it down or cut it out or all sorts of other things. It's very interesting. Most interesting thing I've ever done.
Oh, I can imagine.
This is my 7th year. It's a 7-year appointment. The Chief Justice appoints us. It's a 7-year appointment. We meet annually with him in the Supreme Court building for our annual meeting, along with the Attorney General and the Director of the FBI and the CIA and the NSA. And it's a very interesting job.
I bet. I'm running out of time here. We could go on for an hour.
Yeah.
What a fascinating educational conversation we're having here. For you personally, how much longer on the bench? You've been there for a while?
Well,
Still
the nice
having
thing
fun?
about this job is that you're appointed for life, and so as long as my heart's beating and I'm able to, I guess, continue to breathe, it's a lifetime appointment. The interesting thing for me, you mentioned when you introduced this that I've been a senior judge since 2005. Well, when you take senior status, you sort of opt to do the level of work that you want to, but you don't get paid anything differently. You get paid the same whether you work anything at all or nothing. So people are somewhat surprised when I say, well, I work for absolutely nothing. I don't work for a penny. You're getting my service for free.
That's right. Well, I tell you, what a fascinating career. You ever thought about writing a book?
Yes, in fact, my wife keeps pestering me. I've always wanted to write books, novels, and nonfiction too. So I've written some legal stuff. I've written a chapter in a very highly regarded national book. But I'd like to write novels. I've got probably 400 novels just from my work on the FISA court. I mean, interesting, but they're all classified.
Well, when you get that novel written, come back and see us. What a pleasure.
All right. Thank you.
Thank you so much for
enjoyed it.
spending time with us.
Yeah.
Federal Judge Roger Vinson on this edition of Conversations. By the way, you can see more of our conversations online at WSRE.org/conversations. I'm Jeff Weeks. Thank you for joining us. I hope you enjoyed the broadcast. Take great care of yourself, and we'll see you soon.
Support for this program is provided in part by these corporate sponsors. And by viewers like you.